Okay, let's try this again. We are on. Last week we did articles 1 and 2 for sections 1 and 2 and articles for the union handbook. Now we're on Article 3 and we're going to go into Article 4. Or no, sorry. It was actually Article 1. We're going to do Article 2 and we're going to do Article 2 and 3 today. Now Article 2 breaks down the scope of the agreement. Section 2.1, Section 2, Article 1, single bargaining unit. All employees covered by this agreement shall constitute one bargaining unit. To the extent provided by law, this agreement shall be applied to all subsequent additions to and extensions of current common carrier operations of the employer, and the newly established operations of the employer, which are utilized as part of such current operations of the employer without additional evidence of the union representation of the employees involved, provided that newly acquired operations of the employer, which are not utilized as part of such current common carrier operation of the employee, should not be deemed additions to or extensions of operations of the employer. Now, if the employer purchases a related common carrier business, the employer recognizes Teamsters Local 705 as the bargaining unit representative and shall meet to negotiate proper terms to be included in that new bargaining agreement. Article 3, recognition, union shop, and checkoff. Section 3, Article 1 is the recognition. The employer recognizes and acknowledges that the union and the exclusive representative of all employees of the employer in covered classifications, the employees and union covered under this agreement shall constitute one bargaining unit. So when the employer needs additional employees, it shall give the union equal opportunity with all other sources to provide suitable applicants, but the employer should not be required to hire those referred by the union. Now, if employees are hired through an employment agency, the employer shall pay the employment agency fee. Now, if any, due from the employee. However, if the union has been given equal opportunity to furnish employees as provided herein, and if the employee is retained through the probationary period, this fee shall not be paid until the 31st day of employment. Section 3, Article 2, Union Shop and Dues. Now all present employees who are members of the union on the effective date of the subsection or on the date of execution of this agreement, whichever is the latter, shall remain members of the union in good standing as a condition of employment. Now, in order to assist the union in maintaining the current and accurate membership records, the employer shall furnish the union a list of new employees, and the employer agrees to notify the union when a new employee is added to the seniority list. Now, this notification shall be made in conjunction with the new employee listing. The list shall include the name, address, social security number, date of hire, and the hub or center to which that person is assigned to, shift and classification, or position that they were hired into. The list shall be provided on a monthly basis, and all present employees who are not members of the union and all employees who are hired hereafter shall become and remain members in good standing of the union as a condition of employment after the 31st day. I've already passed that, so I'm good. Following the beginning of their employment are on or after the 31st day following the effective date of this agreement. Now, an employee who has failed to acquire or thereafter maintain membership in the union as herein provided will be terminated 72 hours after the employer has received written notice from an authorized and representative of the union, certifying that membership has been and is continuing to be offered to such employee on the same basis as all other members, and further, that the employee has had notice and opportunity to make all dues or initiation fee payments. Nothing in this section prohibits an employee from exercising their right to file an objection to paying fees not attributed to representational activities as memorialized in the Supreme Court's decision in CWA versus Beck 487 U.S. 735, which happened in 1988. I have not known about that one, so I got to look that up later on for another video. These objectors will be known as fair share payees. All language in Section 3.2 and Section 3, Article 2 and Section 3, Article 3 shall apply to fair share fee payers. No provision of Section 3 of Section 3, Article 2 of this article shall apply to the extent that it may be prohibited by state law. Section 3, Article 3, Dues Checkoff and Joint Dues Committee. Now, the union and the employer shall establish a joint dues committee to review the deduction and remittance of union dues. This committee is charged with the responsibility of ensuring that dues are accurately deducted and remitted in any timely manner to the union. It's anticipated that this committee shall serve as a source of continuing study regarding the most efficient, accurate, and expeditious deduction and payment of dues, including the exploring electronic solutions. Now the union and the employer shall establish procedures for the operation of this committee. Now the employer agrees to deduct from the pay of all employees covered by this agreement the initiation fees, the dues, and or uniform assessments of the union. Now the employers shall be under obligation to pay dues from the first day of employment unless prohibited by law. However, initiation fees and or assessments shall begin with the pay period following seniority. Now dues and the amount that are designated by the union shall be deducted from the first paycheck of new employees, and then from subsequent paychecks in accordance with the specified weekly amount. The union shall provide the employer a weekly amount to be deducted from each employee. The union shall individually specify the weekly amount to be deducted for initiation fees, union dues, and our assessments. Now, for initiation fees and assessments, the union shall notify the employer the number of weeks these deductions are to be taken from the employee. Now, notification of deductions to be made by the employer for the benefit of the union must be received at least 1 month prior to the date that the deduction is to be made. Now, the obligation of the union is to provide this information, and it shall be satisfied by the transmission of a computer file in mutually agreeable format. Now, the employer shall deduct the weekly dues from each vacation week. Now, this will be implemented within 6 months of ratification of this agreement. Now, the employer shall provide a remittance to the union within 15 days following the check date the deduction was taken. With each remittance, the employer shall submit a report by center and or sort listing all employees alphabetically within their social security number and job classification. Now, for those employees who had no deduction for the week, the employer shall provide a reason. In the event the union does not want to receive a weekly remittance, the employer shall provide a monthly remittance by the 15th day of the following month. And however, if this option is chosen, the employer shall make weekly deductions as described above. Now the employer shall provide a list. Hold on. Try this here. Now, the employer shall provide a list of peak season employees to the union. Peak season is usually between November and January. That's when the peak employers come in. They only last about 3 months, and then they let them go. I got hired in before peak season, so I'm good to stay. Now the company agrees to honor the dues checkoff cards for peak season employees. Now, where the law requires written authorization by the employee, the same is to be furnished in the form required. Following the ratification of this agreement, the Joint Dues Committee will meet to adopt a standard electronic membership and dues checkoff form approved by the union that will be included as part of the company's application and orientation process. The Joint Dues Committee will also meet to adopt an acceptable digital platform and methods for the collection, storage, and distribution of the electronic membership and dues checkoff forms. Electronic membership and dues checkoff forms can be only implemented upon agreement of the Joint Dues Committee, and no deduction shall be made which is prohibited by the applicable law. The union shall have the option of monthly deductions within the monthly remittance on or before the 15th day of the same month. Now, on a written request of the employee, payroll deduction shall be made to purchase U.S. savings bond for said employee. Now, the employer agrees to deduct from the paycheck of all employees covered by this agreement voluntarily, and that contributes to Drive. Drive shall notify the employer of the amount designated by each contributing employee, and that are to be deducted from their paycheck on a weekly basis for all weeks worked. Now the phrase "weeks worked" excludes any week other than the week in which the employer earned a wage. Now, the employer shall transmit to Drive National Headquarters on a monthly basis in one paycheck the total amount deducted along with the name of each employee on whose behalf a deduction is made, and the employer's social security number and the amount deducted from the employer's paycheck. The International Brotherhood of Teamsters shall reimburse the employer annually for the employer's actual cost for the expense incurred in administrating the payroll deduction. Now the employer agrees to deduct a certain specific amount each week from the wages of those employees who shall herein or have given the employer written notice to make such deduction. Now, the employer shall remit amounts deducted to the applicable credit union once each week. Now, the amount so deducted shall be remitted to the applicable credit union once each month or weekly. The employer shall not make deductions and shall not be responsible for remittance to the credit union for any deductions for those weeks during which the employee's earnings shall be less than the amount authorized for deduction. Now, in the event that the employer has been determined to be in violation of this article by decision in the grievance procedure, and if such employer subsequently is in violation thereof, after have receipt of 72 hours written notice of specific delinquencies, the union shall strike to enforce the article. However, such strike that happens shall be terminated upon the delivery, and thereof errors or inadvertent omissions relating to individual employees shall not constitute any violation here. Section 3, Article 4, Work Assignments. Now, the employer agrees to respect the jurisdictional rules of the union and except as otherwise provided in this agreement, they shall not direct or require their employees or persons other than the employees in the bargaining agreement involved to perform work which is recognized as the work of the employees in said units. This is not to interfere with any bona fide agreement or bona fide unions. Now, Section 3, Article 5, employers shall have the option of participating in the employer's electronic funds transfer, which is direct deposit, or the employer's check card payment system, or a paper payroll check. New employees shall make this election during orientation, recognizing the mutual benefits and advantages of the systems over a paper payroll check. The union agrees to encourage all employees to select either the EFT or the check card as method of payment. I do direct deposit because it's better, and then Section 3, Article 6, supervisors work in inside work. The employer agrees that the function of the supervisor is the supervision of employees and not the performance of the work of the employees that they supervise. Accordingly, the employer agrees that supervisors or other employees of the employer who are not members of the bargaining unit should not perform any bargaining unit work, except to train employees or to demonstrate safety to them. The employer shall make every reasonable effort to maintain a sufficient workforce to its staff and its operations with bargaining unit employees. The employer also agrees that supervisors or other employees of the employer who are not members of the bargaining unit should not perform bargaining unit work and preparing the work areas before the start of the employer's hub, the preload or operation, nor shall the employer send any bargaining unit employee home and then have such employees work performed by a supervisor or other employees of the employer who are not members of the bargaining unit yet. When additional employees are necessary to complete the employer's operations on any shift or within any classification, the employer shall first use bargaining unit employees, including double shifting, early call-in, including but not limited to the early call-in drivers or overtime. And overtime is only given during peak season, which just ended. The following shall apply with regard to inside work. Within each building, each operation shall maintain a separate list by seniority of those part-time employees and those full-time employees who are interested in performing extra work. It shall be the employee's responsibility to sign up on the appropriate list. The company shall post such list, and employees who are interested in adding their names to the list shall do so on the last week of each month. I check that list each month to see if they have one open. It shall be the employer's responsibility to make sure that their contact information is correct. The employees who are unavailable to work on 3 separate occasions within a calendar month shall have their names removed from the coverage list, but the employee shall be eligible to resign on the list for the following month when extra work is available or when there is a special sort on a weekend or a holiday. The company shall use the Article 22.3 full-time list to fill the required positions by seniority, and then if necessary, they shall use the part-time timers, and such employees shall work as assigned. Full-time employees will be paid for hours worked only. The employee must be qualified for the available work, and double shift employees shall have a seniority among themselves. Now, the full-time employees called in from the list must be capable of covering their normal scheduled work. No employee is allowed to work more than 2 shifts in any 24-hour work period. All extra work offered shall be reviewed by the union steward. Now, during the peak season, Article 22.3, employees may sign the peak posting for extra work occurring after the completion of that bid. If it is determined at any step of the agreement and any arbitration procedure that this section of supervisor working provision in this agreement has been violated, the aggrieved employee shall be paid as followed. If the actual hours worked by the supervisor amounts to 2 hours or less, the aggrieved employee shall be paid for the actual hours worked by the supervisor at the rate of double time pay. The employee's rate of pay at the time of the incident, or if the supervisor works more than 2 hours, the aggrieved employee shall be paid for 4 hours at straight time or actual hours worked at a double time pay. The employer's rate of pay at the time of the incident, whichever is greater. If no aggrieved employee can be identified, then payment shall be made to the aggrievant. Such remedy shall be in addition to any other remedy sought by the union in the appropriate grievance procedure. In the event that any individual supervisor is found to be in violation of the first paragraph of the subsection 3 times in any 9-month rolling period, the agreement shall be paid at quadruple time the employee's rate of pay for the hours specified in the first paragraph of the subsection. That is the end of the Article 2's Article 2, Section 1, and Article 3, Section 3, Article something of the Union Handbook. Next week we'll be talking about Article 4 of Section 4, Article 4 of the article. See, for me, I'm already in the union, so I'm good with that. So, but like I said before, the supervisors are not allowed to have a union handbook or to participate in any union events. They take out like $30-something out of my union stuff every week, which is a lot of money for that. But I'm not going to complain because it actually helps them out in some way or another. So next week we'll have Section 4 up of the article, and possibly 5 too. Every week I'll read like different stuff. So basically, if you ever have a grievance, and if for whatever reason the supervisor sent you home early before the shift, and you're not happy with it, you can file a grievance. They will pay you for the hours that you're supposed to work for that particular day. It could be double time pay or quadruple pay, depending on whatever. A double time is usually offered on Black Friday and Sundays. If you ever come in on a Sunday during peak season, that Sunday is particularly double time, and then Saturdays are time and a half. Like I said, I've been learning a lot from this union handbook. My friend Angie says that once you study that book, you will learn a lot. That is all for today. So if you like the video, you can give the video a like and subscribe to my channel, RBW King. You can also hit the notification bell so you'll be notified when a new video comes out. Make sure to smash that like and subscribe button, and leave a comment. Let me know what you guys think. And if you want to support my work even further, you can donate to my Patreon link, which you can find in the About section of YouTube. And for just a little, it's a few bucks a video or a month, your donation can help go a long way, and thanks for listening. And the video ended up going longer than I planned, but either way, you guys will learn a lot.